else? Nope. Okay, so I think Thomas has said that he would give a brief introduction.
Yeah, I'm very happy to welcome Henrik Olsen at this seminar. So he's professor and associate dean for research at the Faculty of Law, and I've been collaborating with Henrik since I was employed at DIGO actually. And started with a DFF project on public administration and algorithmic transparency. And then we have had a Data Plus project, and now also we have a bigger Northforce project on refugee dissemination, advancing data science in migration law. And Henrik's specializes includes human rights and data science applied to legal research. So I think he is really the right person to give this presentation today.
And I will be giving the presentation together with Sebastian, and I would like to just briefly introduce Sebastian. Sebastian and I are collaborating on an Innovation Foundation Grant Solutions project called Legalese, which aims at developing natural language processing for Danish legal texts and to employ them into the services of law firms and public administration for case handling and for information retrieval. Sebastian has a very solid grounding in the legal tech environment and also does research in internet law and various other topics in law and digital technologies. And we've shared the presentation so that Sebastian will go first, and then I will take over sort of like halfway. That's how we've shared it. So Sebastian, will you begin?
Yes. Wonderful. I hope you can hear me well. Good afternoon, everyone. Nice that we are so many despite the wonderful weather in Copenhagen. And then, as Henrik just mentioned, we'll split the presentation approximately in half and give you some overview on this very interesting development on regulating AI in the EU, AI in quotation marks. We can get back to that. And we'll talk about the proposal for the Artificial Intelligence Act. What I thought is useful maybe is to provide a short timeline and a background for what are we seeing right now, how did we arrive here, and what will be next. And the political will to regulate artificial intelligence is, for example, already expressed in 2017 when the European Council mentioned a sense of urgency to address emerging trends while at the same time ensuring a high level of data protection, digital rights, and ethical standards. Ursula von der Leyen, in her political guidelines in 2019, the political guidelines, a union that strives for more, put forward as one of the key proposals to introduce legislation for a so-called coordinated European approach on the human and the ethical implications of AI. And the proposal we're going to talk about today is the follow-up on that promise by the political guidelines. Followed up on that promise last year in February, and I'm sure many of you had had a look, the European Commission came with its white paper on AI, a European approach to excellence and trust, where actually a lot of the things we see now in the proposal are already flagged as potential avenues on regulating. There was a hearing on the white paper between February and May where many different stakeholders came with input. And importantly, in October 2020, the D9+ countries, that is the digitalized countries in Europe, consisting of 14 member states, and Denmark was the leading member state, and that came with a short position paper commenting on the Commission's white paper and the potential routes set forth for regulation, and noted inter alia that serious risks cannot only be determined by the sector and the application in which an AI application is used, and also that the category of high-risk AI should remain the exception rather than the rule. In the meantime, also the European Parliament, the third body in European lawmaking, came with various resolutions on ethics, liability, copyright, the use of AI in criminal matters, in education, and similar. And this basically is some of the background and paves the way for this very interesting proposal that was proposed on the 21st of April this year. It's called the Regulation of the European Parliament and of the Council, laying down harmonized rules on artificial intelligence, the so-called Artificial Intelligence Act, and amending certain union and legislative acts. The title, as you can see, is really, really broad. It addresses artificial intelligence as such. I've suggested elsewhere that maybe the regulation should actually have a different title that suits better to what it actually is doing. But this proposal, nonetheless, is very comprehensive. It has 89 recitals. That is kind of the remarks that the lawmaker has in the beginning of the legal text, explaining the background and helping with interpreting the articles. There's 85 articles. There is a staggering 9 annexes, and of course also impact assessments. And quite interestingly, and I haven't seen that before, there is currently ongoing a post-proposal consultation by the European Council, by the European Commission. So the European Commission is basically asking for feedback on its proposed rules. And now you may ask, well, what is happening from here? Importantly, this is only a proposal. So over the next years, could be 2 years, could be less, could be more, the European Parliament and the Council will negotiate around this proposal and come with their respective viewpoints, and then in the trilogue come to an agreement at some point. Importantly, even once this agreement is found and we have the final text of the regulation, currently the proposal foresees an application of the regulation only 2 years after its entry into force. So once the regulation is published in the official journal, it would take another 2 years before many of the rules become binding. Furthermore, it's also important to just very briefly, and we can talk about this maybe in the Q&A if you're interested, point out that this is one proposal in a host of proposals that are relevant for the field of broadly understood artificial intelligence. Last year already, there was proposed the Data Governance Act in relation to Internet, recommender systems, digital content moderation, Digital Services Act from last year is quite relevant. Later this year, the Commission will put forward the so-called Data Act. And for 2022, there is a proposal foreseen on the liability of certain AI systems. So today we focus on the AI proposal, the Artificial Intelligence Act, and look at what this might entail. Also interestingly, very briefly pointing out, this is something that the European Commission or the European Union sees as a very important proposal. Margrethe Vestager commented that with these landmark rules, the EU is spearheading the development of new global norms to make sure that AI can be trusted. And by setting the standards, we can pave the way to ethical technology worldwide and ensure that the EU remains competitive along the way. So a very ambitious goal for a kind of global regulatory approach coming out of Europe. And this can be quite interesting to discuss further whether these rules actually have that potential. Interestingly, maybe as a geopolitical coincidence, the US-American Federal Trade Commission, the FTC, just 2 days before the Commission announced its proposal, came with a very interesting blog post, basically pointing towards how the FTC will in the future enforce existing rules more strictly with regards to AI, again, in quotation marks. So what does this proposal do? And I think the first interesting question to ask is, what is the scope of this framework? And the scope can be broken down into material scope, geographical scope, and a time scope. I will focus on the material scope. And the AI Act as a starting point applies to the placing on the market, putting into service, or use of a so-called AI system. And an AI system, the proposal is actually doesn't say much about AI as such. In recital 3, it just mentions that AI is a fast evolving family of technologies. But then there is a definition where after an AI system means software that is developed with one or more of the techniques and approaches listed in Annex 1. I get back to that in a second. And can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. This might remind some of you of the OECD's definition, and it's very much inspired by that. But as mentioned, Annex 1 stipulates these techniques and approaches that need to be used. And Annex 1 looks like this. It mentions machine learning approaches in point A. It also mentions logic and knowledge-based approaches, and interestingly, including expert systems. And finally, in point C, it also mentions statistical approaches, search and optimization methods, and similar. So this leaves us, I think, with an extremely broad definition of an AI system. And we can discuss what would fall outside of that definition. It's very important, however, to see that the scope of this AI Act really only can be understood when also looking at Annex 2 and Annex 3 of that proposal. And Annex 2 regards the so-called new legislative framework regulation. So an AI system would be covered by the regulation if it falls under existing rules, for example, the machinery directive or the medical devices regulation, cableways regulation, toys regulation, and similar. Some of you might have already had contact with the medical devices regulation. More interestingly, the AI Act also stipulates a new annex in Annex 3, where there are 8 specific areas pointed out in which the use of this AI system, I think a very broad definition, would fall under the scope of the AI Act and thereby be covered by some of the consequences that Henrik will describe later. It's also important to point out that this Annex 3 contains 8 fairly broad areas, but then also concrete use cases. And the Commission will be able to update the use cases, but not the areas. That means the headings, they are set by the lawmaker, but the specific use cases can be adjusted and added by the Commission. And this probably still is a very restricted scope of application for many of the AI systems. But I think it's also interesting to point out that the voluntary application of the rules that for these AI systems that are covered by the AI Act is foreseen via codes of conduct. The member states and the Commission are held upon to encourage the voluntary application of these rules to AI systems that wouldn't necessarily be covered by the rules. Lastly, on the scope of AI, of the AI Act, I think it's interesting to ask who is actually the addressee of that regulation. And the primary addressee is the provider of an AI system that is defined as the party that develops an AI system or that has an AI system developed with a view, again, to placing it on the market or putting into service under its own name or another trademark, whether for payment or free of charge, and that is within the European Union. And the provider of an AI system is the main addressee. Furthermore, the user of an AI system is subject to certain obligations that Henrik also will touch upon. And the user of an AI system is not the individual that is subject to the AI system, but the party that uses the AI system to automate processes. Furthermore, also distributors and importers are addressed by the regulation. And if you wonder how these notions come into play, I think it's very useful to briefly comment on the character of this regulation, because the AI Act in many ways is in the tradition of product regulation in the EU and looking at providers, users, importers, distributors. It is importantly not looking at the subject. So the individuals that would be subject to the AI system. So it's not a regulation that would come with new rights for these subjects, but rather obligations on these actors that I've introduced. And Henrik will tell you a little more about how that works and what that entails.
Yes, exactly. So it is very much a kind of product regulation that you see in this AI Act. And the regulation has a risk-based approach, and it kind of operates with 4 levels of risks. And for each of these levels, there are some specific requirements that must be met. And for this presentation, we will focus predominantly on the high-risk AI. And this is because the unacceptable ones would be prohibited. There's something to say about that, of course, what is the precise definition of what is an unacceptable and thereby prohibited AI? How should we interpret the language in Article 5? But we have chosen not to go into that in this presentation. Instead, we will focus on the high-risk AI. The minimal risk, as you can see, are not addressed, and then there's sort of like a general category, limited risk, which requires AI use to be transparent. So, for example, it is a requirement that if you as a citizen interact with AI, you have to know that there is an AI at the other end of the line, as it were. But we're not getting into these categories. We focus on the high risk because this is where you found the most comprehensive regulation and where we think that there's more interest in this field. So let's see what is the requirements if you develop high risk and what are defined as high risk AI. So if we move to the next slide, you can see here it's again coming from one of the annexes, which defines what kind of AI systems are defined as high-risk AI systems. And I shall come back in a minute to say about what are the consequences of falling under one of these categories. But it is worth here just to see we have these 8 categories in Annex 3. If you go into the actual annex, you will see that each of these 8 categories are described in some more detail. But just to list them here, biometric identification and categorization of natural persons is one of the categories. Management and operation of critical infrastructure. These could be things like water supply, for example, traffic regulation, and so on, are forms of infrastructure. Education and vocational training is another one. That could be, for example, marking or categorization of students, either in public school or at higher schools, even at the university. Also, employment, workers manage and access to self-employment. This could be like using, for example, hiring algorithms used to hire people. It can also be like in this case we've heard about, for example, what are they called? Nimly.com, I think, providers of food and how they manage work performance among their personnel. Another category is access to and enjoyment of essential private services and public services and benefits. These are things like credit scoring, for example, or how to deploy urgent services like, for example, fire extinguishers. How is it called? Fire brandvæsen. How do you say that in English? I forgot right now. And also urgent medical services, for example.
Henrik, if I may add, maybe one interesting example here is that is specifically mentioned in the actual use case regards the deployment of ambulances. And you might be aware of the Danish startup Corti AI. They've been in touch a lot with the European Commission. I think they're actually a very favorite case of the Commission. And they would, for example, fall under that category of high-risk AI.
Yeah, so AI that listen into 911 calls and help humans to make decisions about how and at which speed to deploy these kind of services. Another category, also very relevant for us, of course, is law enforcement, the deployment of AI in police, predictive policing, and so on, which is something that is already in use many places, is also considered to be high risk. Migration, asylum, and border control management. Thomas mentioned in the introduction that this is one of the areas that we are working with, are also covered by this high risk regulation. And then finally, administration of justice and democratic processes. That is, if, for example, AI is used for the purposes of meting out sentencing or to help decide whether somebody is guilty or if somebody should be, for example, imprisoned on various grounds, perhaps even before final judgments. And we also have an example of that, which is already in use in the US. So again, it's some technology that is familiar and which is already in use. So before we move to the next slide, it might also be worth pointing out areas which are not mentioned as high-risk AI systems, although we would think that it is high risk. So for example, AI used for military purposes are left out here, probably for political reasons. Also, development of new pharmaceuticals, development of new industrial products and so on are not mentioned here. To some extent, they are covered by this other framework in Annex 2 that Sebastian was mentioning earlier, but it's not flagged here as high-risk AI systems. But as Sebastian also mentioned earlier, this is a dynamic list. So the Commission may later on add new content to this and may even add new categories. So this is just a starting point for you to be aware of. So on this background, and we can go into more detail later and then have a look at the annex if you wish. But now, what are then the requirements? Assuming that you have a system which falls under the category of high risk, what are the consequences of that? What does it mean to be listed as a high-risk system? What are the requirements that you have to fulfill? And there is a number of requirements that you have to meet, and these are listed here on this slide. I will go into it a little bit. First of all, on Article 9, there's a requirement of a risk management system to be both established, implemented, documented, and maintained. And the requirement for these risk management systems attached to these AIs is that they must consist of a continuous iterative process that must run throughout the entire life cycle of a high-risk AI system, requiring regular systematic updating. So in other words, it's not enough that a risk management system covers the various risks that are foreseen at the time of developing the AI, but there must be a continuous iterative process. And this, I think, is understandable in light of some of these systems being dynamic AI systems that develop over time as they pick up new data after they have been put in place. There's a lot of detail in Article 9 describing these risk management systems. It would take too long for me to go into every single detail. So I think I would just stick to this. And the same goes actually for all these articles. We could have an entire presentation on each of these articles, I think, and perhaps we can do so at a later point. Article 10 sets out requirements in regards to data and data governance, and this is also quite comprehensive, actually. The high-risk AI systems which make use of techniques involving the training of models with data shall be developed on the basis of training, validation, and testing datasets that meet certain criteria. And just to read out from one of these criteria, it says that training, validation, and testing datasets shall be relevant, representative, free of errors, and complete. Oh, that was my AI system on my phone that just wanted to help me. Sorry. So it is quite comprehensive and quite strict requirements in regards to data and data governance for these high-risk AI systems. Also, in regards to Article 11, there is a requirement of technical documentation, and the technical documentation must be drawn up in such a way that it demonstrates that the high-risk AI system complies with all the requirements set out in the regulation. So there must be technical documentation for both the data, for the risk, for record keeping, and so on, which I shall come back to in a minute, and also for transparency and so on. So technical documentation, and this technical documentation is used, as I shall come back to, also as a basis for issuing certifications or certificates to these AI systems, because there's a certification system that will be put in place as well. Record keeping, I won't say so much about that. I think this is pretty standard for most AI systems, having logs and so on, keeping track of how these systems operate. But Article 13 is important. I think transparency and provision of information to users. This is, I think, quite an important requirement. It says that high-risk AI systems shall be designed and developed in such a way to ensure that their operation is sufficiently transparent to enable users of these systems to interpret the system's output and to use it appropriately. An appropriate type and degree of transparency shall be ensured with a view to achieving compliance with the relevant obligations of the user and of the provider. So this is very important, and the interpretability now becomes a legal requirement for these high-risk AI systems. And then human oversight, which is also very important, I think. This is to ensure that automated systems are not, in some sense, fully automated, because there must be scope in these systems for humans to oversee these AI systems and to be able to follow how they develop, to make sure that they don't induce new risks. And it must also be possible to interfere with the AI systems. One of the requirements in the human oversight is also that the system should be built in such a way that users remain aware of the possible tendency of automatically relying or over-relying on the output produced by these systems. So there's, other words, here also a regulation which addresses the issue of automation bias. And then finally, also, I think something that is probably in use in most cases today, there's a requirement for robustness and cybersecurity, but there's also this accuracy requirement, so that it must be the case that these AI systems are actually bringing forth accurate decisions or accurate recommendations, or provides the user with accurate data when it is used. So there's a certain level of performance in terms of accuracy that these systems must meet before they can be certified. So if we now move to the next slide.
Henrik, maybe just briefly for context. So these requirements, very important, relate to the design and development of these AI systems. So they're stipulated on the provider of these AI systems. If you think back about who are the actors that are addressed. So human oversight relates to the requirement of, in the design and development, ensure that there is human oversight. Users, on the other hand, the users of these AI systems are subject to other obligations, most notably to use the AI system in accordance with the specifications by the service provider.
And just to add to that, it means, of course, that this is also relevant to developers of new AI technologies, and in that sense, it's also very relevant for data science research. And I think there's a lot of scope here for collaboration between the law department and the DIKU going forward, trying to interpret what this means in terms of developing new technologies. Yeah, so let's have a look just here finally. So this whole set of regulations are then kind of wrapped, as it were, in a regulatory oversight and control mechanism. Because there are built into this regulation a number of compliance requirements. It means that providers of AI has to comply, and they have to document that they comply. Before an AI system is brought to the market, the provider has an obligation to go through a procedure where there is a conformity assessment. And this conformity assessment, and we don't know yet exactly what the setup will be in Denmark for this, but there's some kind of standardization body. I think Dansk Standard, for example, could be an authority which could be tasked with this. And there will be a certification system. So an AI provider who want to bring to market a high-risk AI system must contact, for example, Dansk Standard, if that is the option, asking for a conformity assessment. And this conformity assessment, if it is passed, will then lead to the issuing of a certification. And the national notifying bodies, those who notify and issue certificates, will in turn also be supervised and checked and controlled by an EU oversight body. So, and that is to ensure, of course, that there is homogeneity in the market, and that these national bodies that issue certificates all act on the same interpretation of this regulation. And once these certificates are issued, they will also be stored in a common European database where everyone can go and check up on these certificates and get access to the various technical documentation that is forming the basis for the issuing of this certificate. In our meeting with our legalese partners, there has been some concern raised. We can also see that in the public debate that this is a very bureaucratic system, and there's some concern that it will be very costly, especially for smaller companies if they want to bring new technology to market, that they will be burdened with these high costs of getting access to necessary certificates. So it's just to say that there is some concern in the industry that this will slow down development. On the other hand, you could also say that there is an advantage with this procedure, because it kind of brings the market, as it were, to a standstill, where all providers, including the big US firms who are dominant on the market at the moment, they have to rebuild, as it were, some of their business models if they are to meet the criteria that are set out in this new regulation. So there are, of course, pros and cons with implementing this model. So I think that was pretty much what we had to say by way of an introduction, and we wanted to leave room for questions. We wanted to leave room for debate and comments. So I think I will end here. I don't know if you have something you want to conclude as well, Sebastian, before we hand it over to the audience.
Yeah, maybe we can just maybe point out again. So first of all, very importantly, this is a proposal for a regulation. So this will now be discussed and drafted by policymakers and other stakeholders. And this also means, of course, that there might be a role for you in this process to look at this instrument and see what makes sense, what doesn't, how could this be improved, etc. It's also important to point out that we only touched upon some central, but only some of the parts of the regulation. And you might wonder, with all these new obligations when developing AI systems, how will this work? There is, for example, stipulated a administrative fine system akin to somewhat what we know from the GDPR, with up to 6% of the annual global turnover as an administrative fine, for example, for the requirement of data sets to be free of errors. Lastly, there is also a big question mark around the setup in the different member states for this enforcement, and regulatory sandboxes or AI sandboxes that should provide more free room to develop AI systems nonetheless. But I think that is pretty much the overview we wanted to give you, and we look very much forward to the questions and discussion with you.
Thank you very much, Sebastian and Henrik, for this really, really insightful presentation. If you have any questions, please raise your hand, not your actual hand, but your Zoom hand, so I can see who has a question. think the first one is from Christina.
Thank you, Isabel. Thank you for the presentation. So I do not know if you covered this at the beginning of the presentation. I missed it, but is this law, if this regulation, if it is implemented, will it affect technology that is developed or owned by EU stakeholders, or also technology that is used in the EU but is developed or owned by, let's say, US or Chinese stakeholders?
Christina, exactly. You point towards a very interesting question, which is kind of the geographical scope, and maybe Henrik wants to supplement then, but I can just give it a shot. So as a starting point, this proposal sets out that the rules would apply to the placing on the market, putting into service, or the use of an AI system in the European Union. That would mean if an AI system is developed elsewhere, but used in the EU, it would have to comply with those rules.
Yeah, and I would like to add a little bit to that, because I think that you should also see this regulation as part of a geopolitical move by the European Union. There's a perception among politicians, I think, that AI as a technology is very important and crucial for both the economy and also for political influence and so on. So overall, the idea is that there has been developments in the US on AI, which are predominantly and increasingly influencing developments in Europe, among other things through access to data and so on. And simultaneously, there's also a development in China on the same front. And both of these developments are considered by the European Union to be somewhat threatening, and also stand in the way of a more, if you like, democratic use of artificial intelligence. And so this regulation, just like the GDPR, wants to kind of reset the developments by bringing in new requirements that has to be met by technology users, and thereby indirectly will impact on how these technologies are being developed.
Thank you. And may I ask a second question?
Yes, please go ahead.
Do you have any definition or description of what is an error in the training data?
What is an error in the training data?
Yes, what is an error?
No, we don't have any description of that. I think that will depend. It's a concrete assessment of what would be probably the state of the art in a specific field. What is considered an error, and it would have to relate also to the specific tasks that the AI is supposed to perform. I think it should be seen in the context of this accuracy requirement as well.
So, for example, if there is a data sample where 85% of the features belong to males and the rest to females, is that an error?
I don't think it depends on whether it's the data set is complete. It's not necessarily an error.
So you have one criterion is errors and the other one is completion of the data set. And by that you mean the balance in the features of the data set?
I can go back to this requirement on data. It says here, just a minute, I'll find it again. It's in Article 10. It says here that high-risk AI systems which make use of techniques involving the training of data models with data shall be developed on the basis of training, validation, and testing datasets that meet quality criteria referred to in paragraphs 2 to 5. And then there's a number of requirements, there's quite a lot of them. And one of them is that training, validation, and testing of datasets shall be relevant, representative, free of errors, and complete. They shall have, and now I can read a little bit more. Oh, you have it already there. Yeah, yes. Exactly. That's the text. Thank you, Sebastian.
What is a complete data set?
Christina, maybe you can help us. What is a complete data set? And And the proposal doesn't really stipulate more on that. I also think the recitals remain surprisingly silent. And this, by the way, I'm sorry, I'm sharing, I only have the PDF version that I annotated myself. So you see my highlights and comments, and I wrote wow next to it, because I wonder a little, complete data sets free of error, what is the benchmark for that? And that is kind of, I think, very vague in the proposal right now. So maybe let me throw back the question to you. I mean, what would be the benchmark for a complete data set or a free of error data set?
Well, this is one question one may ask. Another question is it possible to have a complete data set or a data set that is free of errors?
That's a very good question. I think it depends on the use of the AI. I mean, it should be seen in the context of the use. So whether a data set is complete or not, a training data set is complete or not, it depends on the use of that system. So completion must be relevant to use. So
has a computer scientist defined this terminology? Has this been checked and approved by people who develop AI technology, these concepts of completion and no errors in the training data?
It's a legislative text, and there are a number of people who has been in this what is it called, high level AI
expert group.
Yeah. I think that a lot of people has been in there. I haven't checked whether there are any specific data scientists members of the group.
Okay.
If I may follow up on that, Christina. So I'm not entirely sure, of course, about the workings with the European Commission, but I've been involved in another proposal in the Digital Services Act with the European Commission. And this comes out of DG Connect, and the units usually have kind of a collaboration around this and their studies beforehand. The impact assessment to this proposal gives a little more guidance on what the Commission used as empirical evidence for its proposal. But I think the work of the high-level expert group is one of the important parts, as well as the reports by the Parliament, etc.
I understand. I do not want to take more time, but very briefly, I want to say that if a system is trained on data that is perfect, then it will not work very well in real life, because real life is not perfect. So the data has to be realistic. But anyway, I'm sure you will hear that from other people. Thank you.
Yeah, but there's no requirement that data is perfect. It's just that the training data has to be complete,
okay,
relative to the task.
You're right.
Yeah.
Let me rephrase. Yes. If the system is trained on data that is free of errors, and I do not know what you mean by complete, then it will not work very well out in the real world, because the real world is not free of errors.
All right, we have 3 more people with raised hands. The first one was, I think, Abraham Smith.
Hi. When we're talking about requirements for data sets being complete and free of errors, which is, of course, impossible, I'm also wondering about products which may provide users with the ability to add their own data. So you may be providing a product to someone that would have sort of what's called like online learning capabilities, where people could actually, with human oversight, maybe modify the data or add to the data, and how would responsibility be shared in that sense of keeping things in line with this proposal?
So your question is how to deal with artificial data?
Not artificial data, real data that is. So let's say you had an AI product or system that you provided to a hospital, that you allowed the hospital to add to the data. Let's say they added complete and error-free data, which isn't really a thing in the real world, but let's say that they were able to do that. Is that even a thing that's allowed to happen? Are people allowed to add more training data and more labels? And how is responsibility shared in that sort of circumstance?
Well, if I should give a shot at answering that, then I think in this case, the hospital would be a co-developer of the AI system. So they would actually be entering into a kind of relationship with the developer before the AI system is put to use, and that is before it is put to the market. So it would depend on the contractual relationship between the hospital and the AI developer.
And I can maybe just briefly add, so the proposal has an article with definitions and defines training data, validation data, testing data, but also input data. And maybe the answer can be found there in terms of the design and development, and then the difference, which is later on relating to the use of that AI system and the requirements that the users have, and also the requirements that the developer of an AI system has in terms of post-market monitoring, etc. So I don't have a super sharp answer for your very good question, but I think the key lies here in the differentiation of data used for training, validation, and testing purposes, and then later on in the actual use of the AI system.
Thank you.
All right, then we have Anna next.
Thank you. And thank you for organizing this. This is amazing, and I wish more of my colleagues from SODAS found about this unattended. We are also working on these questions. We have 2 papers on data governance just this spring. So my question is to go back to Christina's point on these definitions about how data is supposed to be complete and representative and free of errors. The word representative, do you think they mean that people will have to specify which populations given data set would be supposed to cover? Because you can't be a representative in the abstract, you have to be a representative of a certain phenomena in a specific population, right?
Yes. Again, I think the answer there is that it must be relative to the use of the AI. So the representativeness of the training data should be viewed in the light of what the AI system should be used for subsequently.
So let's say we have some system which is predominantly used by men. Does this then give the developers a leeway to not put as much effort into making sure that it also works for women?
No, I wouldn't think so. I cannot imagine an AI system that is developed for the purposes of catering specifically or preferably to men.
No, but let's suppose that the representative user base happens to be predominantly men.
No, I wouldn't think that would fall under representativeness in that sense. That would be my view. I mean, you have to remember as well the broader context of EU legislation here. There is a prohibition on gender discrimination under EU law, so that would simply be illegal on other grounds. It's not something that is specifically regulated here in the AI proposal, but that would be illegal under other parts of EU law.
Okay, so pretty much any AI dataset, even now, even before this goes into effect, does have to ensure gender representation.
If it is resulting in a discriminatory use, it's you have to make a distinction here between the training data set and the use. So this new regulation here connects the training data set and the use, right?
Right.
So representativeness should be regarded here in regards to use, and then once you put that into use, then you are covered by the broader EU law on anti-discrimination. I don't know if do you have anything to add to this, Sebastian? I think this is my best shot at an answer.
Yeah, I'm not so sure how much I can add, but let me quickly point maybe to a very interesting study by one of our colleagues, Raphael. I can send maybe a link. She wrote a really interesting study on the question of anti-discrimination law and AI. Apart from that, your question might also relate to something else. And again, back to my question, what is the benchmark? And in these obligations regarding the development and design of AI systems, the benchmark appears to very often focus on the intention. So the intention of how this AI system is supposed to be used. And in the risk context, then there's a differentiation when it is for the intended purpose or when it's also reasonable misuse needs to be foreseen. So that's, I think, a question also of the benchmark on how, what kind of the requirements exactly are for the data sets. That's, I think, my best shot.
Yeah, we can circulate this paper afterward. We have a Marie Curie researcher who's dealing specifically with gender bias and in AI.
Nice, thank you. Then we have a question from Hugo in the chat. Hugo, would you like to read out your question?
Yes, well, to me, it's much more, I want to dig a little bit deeper on this question on completeness and representativeness, because it seems to me that if I basically take a complete data set that has historically certain bias, then I would just base my model trained on that will just basically reinforce those bias. So I wonder what what we want here. I don't think that we can get both things at the same time, both representativeness and completeness. And well, yeah.
Yeah, but Sebastian already found one of the recitals here, and it's also covered actually in the regulation text itself in one of the articles. I can't remember which one on bias. Maybe you want to just go through that, Sebastian, what you have on the screen there.
Yeah, it's so there are several aspects that relate to this. I mean, both in terms of debiasing basis for personal information processing, but I just want to point in recital 44, which also relates to Article 10, to this sentence of, in particular, training, validation, and testing data sets. And again, it's training, validation, and testing data sets, not use data sets, should take into account the extent required in light of their intended purpose, so the intention of the purpose of the AI system, the features, characteristics, or elements that are particular to the specific geographical, behavioral, or functional setting or context within which the AI system is intended to be used. And I think that is kind of maybe a guidance as to how to interpret these requirements. That's my best bet, at least.
Maybe I could also add to you, Hugo. Assume that you have a complete data set, and this data set shows that that practice is somehow biased, and an algorithm would pick up that bias. There is a requirement before putting it on the market then to debias the data set. That does not make the data set incomplete. The data set is still complete, but the use, putting the AI into use, the provider must ensure that it is not discriminatory when it is used.
But doesn't that mean that we're also manipulating and manipulating the data set?
You don't manipulate the data set, I don't think. What you do is that you create an algorithm that takes into account gender when you provide an output and put that AI system into use. You don't change the data set, but you just you don't allow the algorithm to pick up the bias and move that forward into the recommendation.
Right.
If I just wanted to say one thing, because in the last paragraph that you mentioned, there was also there was a question on features, and I think there are certain obvious features we could look at, like if my data set has information regarding male and female, we can test on that, but not in all cases that the feature is that direct. I can get some correlation on things like that the men use shoe size that are bigger. So how do we really test all these set of features that we can get? It seems that it's a bit too big and fuzzy, this area, but it's probably my opinion.
All right. Then Christian, you had a question? You're muted.
Just a comment. So because this completeness, this is also something where I struggled over. So what does it mean, a data set to be complete? Because that's a term we typically don't use in machine learning research so much. But there are areas where people reason about data quality, and it has a particular meaning. And just because it seemed to cause some confusion, just let me read one of the definitions that is out there. That is basically data set is the completeness of a data set measures the extent to which data are sufficient depth, breadth, and scope for the task at hand. So this is actually a very fuzzy term, and I'm pretty sure that it's meant in this because mathematically it doesn't make sense, right? Because a finite data set cannot be kind of complete, giving, for example, a continuous data distribution. So it has not this mathematical meaning in that sense, because then you could directly lead to an ad absurdum argument here. So, but there are research articles, a lot of if you go to the wiki page on data quality, then you find the several links what people mean by data completeness, and this is what is, I guess, also meant here.
I think that's a great point, Christian, and it also emphasized what I mentioned earlier when you say, I mean, relative to the task at hand. It's precisely that. It has to be relative to the use. I agree.
Thank you, Christian. Then Thijs is up next.
Yeah, thank you. So thank you for a very nice presentation, Henrik and Sebastian. So I was wondering, can you say something about how likely is this regulation? And I'm thinking in particular about kind of the requirements for standardization. How likely is it to be touching us as researchers? So I'm thinking very specifically, for example, let's say I create some algorithm to kind of predict decisions in asylum cases. Now I put this on GitHub, I write a paper, I publish that. Am I going to be on the hook for this? Like, do I have to get this standardized somehow, or can I do this without having to worry about this regulation?
So, do you want to give it a shot, Sebastian, or shall I?
Yeah, I can briefly maybe comment on one particularity that I find quite interesting. So Article 5, which comes with these prohibitions, which are very, very difficult to understand, I think, what is actually meant, but it's profiling, etc. Biometric identification, etc. Even that is in the recital exempted for research purposes to some extent. The question is, and that leads back to my point on the scope, putting into market use of, that is kind of the relevant criteria. The question is then, is your research only research, or will it also be used? And that's a very difficult gray zone. So maybe Henrik, you, because we have discussed this also, what exactly is the relevance in this pure research, and then moving maybe into something else, how these graduations look.
Yeah, we actually had the slide up on which defined the various roles, and researchers aren't defined in this regulation. I mean, it's only if you can be seen as a provider of an AI system, and I don't think that the researchers are providers. I mean, unless you actually plan on somehow selling this algorithm somehow. I mean, I think it's too far from being a provider. You know, just doing research, developing new algorithms, and so on.
So, just if I can follow up on that, even if I put it on GitHub, make it open source, I would like still not be the provider. I would be the person actually taking this and implementing it for.
Yeah, okay, Sebastian is a little bit more uncertain about this.
I really don't want to answer that question in black and white fashion, because I don't know how the interpretation of placing on the market would be perceived, right? If you put this, if you commit this on GitHub with a nice open source license, go ahead and do whatever with it. I don't want to commit to saying this is not placing on the market. So I think we need to dig a little deeper there. I don't know. So guys, be careful. Don't take us as legal advice. In any case, I mean, again, a reminder, this is a proposal. So this will be probably look a little different once it's the final act.
Thank you.
Thank you so much. So we've come to the end of the hour, and I've been told that Henrik has to leave as well. So I'd just like to say thank you to both of you, Henrik and Sebastian. Thank you so much. This was really, really relevant to a lot of us who are working with AI and with applying it to various problems. And yeah, I mean, you can see that there is a lot of interest and people would like to discuss it further. So maybe we can find another slot where we could have another kind of chat or brainstorming session or something along those lines. Yeah, so
we would be happy to be back. Perhaps we can meet physically next time.
That would be nice. All right. Thank
Okay.
you so much.
Thank you very
so much, everyone.
Thank you for all your questions. Thanks.
And feel free to follow up, of course, also directly via email with Henrik and me. So thanks so much. Have a nice afternoon.
Thank you.
Bye-bye.